This is You and the Law on AM 650. Now back to the show.
Good to have you with us on this episode of You and the Law. Christine Eilers and Angela Thiel with Lindsay Kenney LLP in Vancouver. Our guests were talking family law on this program. And I wanted to return to a subject that we've touched on a few times through the conversation so far. And that's this whole matter of cohabitation. Living together, living in sin, as it used to be known back in the 60s. And people still do. A lot of people forego the formalities of marriage and have long, successful relationships. Are the rules, first of all, we talked about the new act and how it recognizes cohabitation. What's the timeline? How long do you have to live with someone before the law recognizes you as being cohabitants and therefore equal distribution of assets under the law?
2 years.
2 years. Okay. So what about a situation in which you cohabit with a person who has children from a previous relationship? How does that alter the landscape, if at all?
Well, you take on an obligation, a financial obligation for that child after 1 year.
Oh.
Of in essence, directly or indirectly supporting that child. So if you are prima facie a step-parent,
right,
and the natural father who's really supposed to pay for those kids, he makes $20,000 and you make $100,000. Well, you've just taken on the child support difference if the marriage breaks down between $20,000 and $100,000.
So the law is, even though they're not prepared to recognize our relationship as being a cohabitation situation until after 2 years, where children are involved, the law makes an exception because of the children, I'm assuming, Christine. Is that that's why the exception, to make sure those kids are looked after?
Yeah, I would say that's the reason for it.
And I forgot, of course, that cohabitation doesn't have to be 2 years if you've had a child together.
For the purposes of spousal support.
Okay. So if you're just living together, no children, 2 years after that beginning, the law recognizes it as a formal legal relationship. But if there are children produced in less than 2 years, then the recognition is advanced to the birth of the child.
For certain purposes.
Okay.
So for certain legal issues, if you have a child in that first 2 years, you will be recognized and be given certain rights that you didn't otherwise have before.
Right. What about children's rights? I mean, Shakespeare wrote about bastard children, and society over millennia has seen it fit to look down its collective nose at children who are quote-unquote illegitimate. That's a very antiquated concept in 2013. Is it the same in law? Has the law gotten way past all of those crazy old slogans and notions?
The law got past that in 1984 or so with the Charter of Rights and Freedoms. So yeah, you're very antiquated.
Well, but again, so are a lot of people in British Columbia who don't spend a lot of time around law books or lawyers. We don't know these things. So, I don't know. So I thought it was a fair question to ask. I mean, I know it's old school and some of the language was bizarre, but I mean, there's still a societal attitude out there that's still prevalent, not as widespread as once, but in certain cultures particularly, it's still quite prevalent.
And certainly when I started practicing law, you were having people come in. It used to be that if you had a illegitimate child, you could agree to pay very little in child support, and those agreements were binding.
Yes.
And so the parents, when the law changed in '84, I was a young lawyer. I had a number of parents coming into me saying, I got this agreement because, some social worker back when I was a teenager said, well, he's going to pay you $5,000 and that's all the child support you're ever going to get.
Right.
Are these enforceable? Now we've got this new Charter and Rights of Freedoms, and I happen to know the father of my child now makes $100,000 a year.
Right.
So that's why I know so well when it changed, because I was involved in some of those cases in the early days.
I wanted to ask you, this is kind of off track, but it's still under the general heading of family law. And we mentioned this, Christine, earlier a few moments ago, given the relative freshness that you bring to the firm just out of school and such, and some of the cases that you're dealing with were unheard of even 10 years ago. Now we all know about same-sex couples and marriage in certain jurisdictions. So clearly, The downside of that is going to be same-sex couples divorcing.
Absolutely.
Have you experienced, either of you in your practice, experienced this yet?
Well, in fact, after we leave here, I'm going to go swear an affidavit for a same-sex wife who is claiming a divorce, and then you have same-sex couples with children.
Exactly. Yes.
Those cases have been around for a few years because it's this question of, well, I happened to give birth to the child as one part of the same-sex couple, but we were it's no different than husband and wife.
Right.
So
does the law see it that way too?
Generally, it does. Yes.
Okay.
Yeah. You have the same rights as the sort of supportive parent as the parent that gave birth to the child, and then you have.
And that's been codified under the new law.
Okay. Right.
But we've actually had cases where two gay couples. I think it went two gay couples. The one woman gave birth to a child for the male half of a male same-sex couple,
right.
And then they were supposed to provide sperm so they could have,
right.
And they were sort of raising this child as a foursome, and the courts had to consider that. I think that was in Alberta.
Oh, boy.
Yeah.
That'd be a tough one to unravel. What about grandparents? Only a couple of minutes left here, but I wanted to make sure that grandparents, under the new law, it's only a couple of months old, are there any improvements for grandparents who become alienated through breakups of relationships? They're still the grandparents to these gorgeous little children, and all they want to do is to see them and to have access to them and hug them. And sometimes there's just World War III breaking out, and grandparents are the first casualties of the whole thing. Has the law at all accommodated grandparents in any greater way with the new act?
The new act language is virtually the same. I mean, if your child, the father is getting access to the children, you're supposed to exercise your rights, to see the kids during dad's time. Where grandparents have always had a right and been fairly successful in the court is if the parent, their son or daughter, perhaps has a drug addiction or some reason why they can't see the child.
Right.
Grandparents have always been pretty successful in going in and saying, well, we want to keep the family ties.
Right.
And we recognize you don't want this child in the custody or in the parenting time with this addicted,
irresponsible individual.
Irresponsible.
Sure.
But there's nothing irresponsible about us. We love the children. We'd like to have some time.
And they're our grandchild.
And they're a grandchild.
Right.
Exactly.
Okay. So there are accommodations that can be made.
And the court's been relatively, I think, has been quite welcoming to a grandparent who says, look, everybody wants to be here to love this child. Why wouldn't you give me time so that we can prove that our side of the family still loves you, even if, dad has got some problems.
Always nice to end a program on a positive note, and that was a nice one to do. Well done. Angela Thiel and Christine Eilers from Lindsay Kenney LLP, thank you both for coming in. Just a fantastic conversation. Let's do this again.
Thank
Thank
you.
you.
Yep.
We'll see you next time on You and the Law.